Hello, everyone. I think we'll give folks just a few seconds here to log in. We're so excited that you were able to join us today for the webinar, Does Antitrust Help or Hinder Sustainability? We've already gotten into a lively chat in the few minutes preceding this webinar, so going live. So I'm really excited to dig in with our panelists today. I can see folks already at about 80 people in, which is fantastic. Just give folks a little bit longer. And okay, I think we should get rolling. So again, welcome everyone. My name is Denise Hearn. I'm a writer, applied researcher, and advisor whose work focuses on how economic power and paradigms shape our world. I co-authored The Myth of Capitalism, Monopolies and the Death of Competition, which is, I think, out in paperback this week, if anyone would like to pick up a copy. I'm working in partnership with the two centers at Columbia University on a landscape analysis and research project looking at the intersection of sustainability and antitrust, which is what brings us together today for this webinar. This larger project is a collaboration between the Columbia Center on Sustainable Investment, which is a joint center of the Columbia Law School and Columbia Climate School, and an applied research center that works to develop critical understanding, practical approaches, and governance tools for governments, investors, communities, and other stakeholders to maximize the benefits and minimize the potential harms of international investment from sustainable development. And Lisa Sachs is the director of CCSI and the mastermind of this project, so thank you, Lisa. And it's also in collaboration with the Sabine Center for Climate Change Law, which is an academic think tank at Columbia Law School that develops legal strategies to fight climate change. Cynthia Hannawalt, who is a senior fellow there, has been a close collaborator on the project, so thank you both. A few housekeeping notes. We will be having about 35 to 40 minutes of discussion with the panelists, and then we'll be taking audience questions. So please put your questions in the Q&A box at the bottom of your screen, and we will get to them. I also have the list of questions that you submitted ahead of time, so we can try and answer some of those as well. Okay, let's jump in. I'm going to introduce our panelists. I tried my best to cut down their bios, otherwise they would take up the entire webinar with how impressive they are, but I'll do my best here. So we've got Maurice Stolmans, who's a partner at Clearly Gottlieb, Steen & Hamilton LLP. His practice focuses on EU, UK, and international competition law, especially in high-tech and EU intellectual property law and sustainability. We've got William Kovacic, Global Competition Professor of Law and Policy at George Washington University, also Director of the Competition Law Center, former FTC Chair from March 2008 to March 2009, which sounds like a wild time to be FTC Chair, and also the agency's General Counsel for a number of years. And since August of 2013, Professor Kovacic has served as a non-executive director with the UK's Competition and Markets Authority. And he is co-editor of the Journal of Antitrust Enforcement. Next up, we've got Jeff DiMartino, partner at Baker & McKenzie LLP, where he co-leads the firm's Global Cartel Task Force. Prior to joining Baker McKenzie, Jeff spent nearly 2 decades at the DOJ and his last 5 years as chief of DOJ Antitrust Division in the New York office. And Catherine McKenna, Canada's former Minister of Environment and Climate Change, as well as Minister of Infrastructure. She is the principal of Climate and Nature Solutions, chair of the UN Secretary General's high-level expert group on net zero commitments of business, financial institutions, cities, and regions, and a distinguished visiting fellow at Columbia University. And interestingly, before entering politics, Catherine was competition and trade lawyer. So she's got a fantastic background to weigh in on these issues today. So just a quick reminder of why we're all here, what we're going to be discussing. Industry players at both the investor level and the corporate level are increasingly wanting to collaborate on sustainability goals like achieving net zero greenhouse gas emissions. And antitrust law aimed at fostering robust competition in markets is perceived as a barrier to these collaborations. There's questions and confusion about what forms of collaboration are permissible under the law, and activities such as joint standard setting, what kind of information sharing businesses can do, shared norms and practices are now being revisited. So we're going to look at what the EU and the UK have been doing, and also look at the differences across jurisdictions, and also hopefully get into a lively debate about, some of the green antitrust movement, whether, that will be successful in achieving its sustainability aims, or, where there might be potential dangers there. So I'd like to kick it over to Catherine to get us started. Can you give us an overview of the issues as you have seen them arise in your work on net zero commitments of non-state actors? And how are investors and companies trying to move towards net zero? Why do they perceive antitrust law getting in the way of those efforts?
Well, thanks very much, Denise. I'm both a recovering politician and a recovering antitrust lawyer. But it's interesting how worlds collide. And I do think it's really important that we both trade and antitrust are consistent with our broader environmental goals, and we still have a ways to go. Look, so I was asked by the Secretary General to chair his expert group on net zero. And the reality is we know businesses are absolutely critical for the world to achieve its net zero goals. And to do that, I mean, I've always been a believer in certainty. I think it's really good to set out what is required when you're going to have goals, both long-term goals, which is the net zero goal by 2050 or before. But the problem is you also need to have short-term goals, and you actually have to do things. The easy thing, as I've always said, is like, put up your hand, say, I'm going to be net zero. The hard thing is actually to deliver on the commitment. And so this report, it provides some context, because what we tried to do, people can go read it. It's only 10 recommendations. It tries to provide some clarity on what's required. And there's some things you need to do, short-term goals, short-term targets. You need to, essentially reduce emissions starting now, and scale money from dirty to clean starting now, aligned with science-based targets. And there are certain things you can't do, invest in new fossil fuel infrastructure. That was not made up by the expert group. That's actually what the International Energy Agency says, and a number of other things. And the goal is, I worked in the business world, people want certainty. So we have a number of initiatives that are committed to net zero. They're collaborations, they're voluntary, and they've tried to provide some clarity around what is required, because we need diligence. The reality is we're very far. We've made progress. We're very far from doing what our ultimate goal has to be, which is ensure a sustainable planet. And emissions need to go down very quickly. They need to be reduced by half by 2030. So we need to get to work. And so one of those initiatives is GFANZ. So started by a fellow Canadian, Mark Carney, a good friend. And GFANZ has a number of different alliances, industry alliances. These are voluntary, I should emphasize. And these alliances have criteria. There's a price of admission if you're going to be part of it, like anything. And one of the criteria that was updated was to make it clear, as I said, it's not consistent with the science to invest in new fossil fuel infrastructure, but in particular, it said that you needed to phase out coal by a certain date. And there was concerns raised that by, I think, different participants, and we've seen this, different banks, but insurance companies, that this raised antitrust concerns. So you've seen that there's a chilling effect. Now, some people might say, wait a minute, is that just because they didn't like what the criteria or standards were? Hard to know, but there is, I think there are, there are legitimate concerns, and you have better experts than me to talk about what's going on in the US, but even in Canada, where we're updating the Competition Act, this has come up. And the reality is, if we're going to tackle climate change, people need to do things, and they need to be held accountable to those things. And those things are actually real things, like you have to get out of fossil fuel infrastructure. We cannot continue investing billions, trillions of dollars in new fossil infrastructure. So I think we need to move to this. Now, I could do a long thing. If you just go to recommendation 10, it says we need to regulate. If it was all regulated, net zero commitments, transition plans, we would, with consequences, we would get out of this. And that is happening in Europe and other places, but it is, we're a long way, I would say, potentially in the United States, the draft SEC rule, which is more on disclosure. But I think the reality is, from my perspective, we need to make it clear that legitimate competitor collaboration, so legitimate, that's a very key word, needs to achieve real environmental climate change outcomes should be permissible. I don't know so much about other contexts, but in Canada we have an efficiencies defense. But obviously, it's a huge concern. If you're a business, financial institution, you're being threatened by criminal conspiracy provisions of an act that will have an impact on your views. As I say, I mean, we need the GFANs soften the language. They felt that it was then consistent with antitrust law, and that if now your concern was you didn't like what was required, well, that was something that you would have to grapple with. If you didn't like that you had to be public with these commitments, that was something you were going to have to grapple with. That's different from antitrust concerns. So that's really the lay of the land. But the UK has made is out there on this. They recognize that they need to provide clarity to business, that the legitimate collaboration between competitors is okay. As I say, ultimately, it would be great if we could regulate, then we'll get out of this problem. But in the absence of that, I think we need competition authorities to make clear that what the rules are, what's okay. There's a 4-part test, I think, in Europe, but probably better, smarter people than me can explain that.
Fantastic. Thank you so much. And I think what you raise about sort of what is competition policy's problem to solve versus other areas of regulation, I think is an important one. And so, Bill, I'm also wondering if you can help contextualize for us this question about competitor collaborations. Where does that sit within the landscape of antitrust and competition agency remits overall? Because there are other areas, let's say merger analysis or consumer protection, that the agencies are also responsible for, which absolutely have an effect on sustainability. But what we're talking about is something a bit more narrow. Can you talk about that, and also whether these sustainability concerns are introducing something fundamentally new for regulators to consider? Oh, and we'll need you off mute. Thank you.
Thanks, Denise, and thanks to the Columbia community for hosting the event and for the pleasure of participating. Competitors collaborate all the time. They collaborate on a wide range of commercial projects, and U.S. antitrust law has accepted that with one key requirement. The focus of the collaboration has to be activity that improves the well-being of consumers, and that can be broadly defined, but is the collaboration generating a new product? Is it providing better quality for an existing product? Is it stimulating innovation that wouldn't happen otherwise if firms acted unilaterally? All widely accepted, and at least on their websites, law firms declare that they're very good at guiding firms through that process. So that's, I'd say, a relatively well-developed framework. The issue in many ways involves how broadly to define the consumer interest. I suspect at a basic level, we could say, are consumers interested in survival? Are they interested in having a climate that permits them and their families, their successors to live a healthy life? I suspect yes, indeed. Competition law, I think, has had a difficult problem dealing with what could be called regulatory policy failures. That is, if we wanted to have a serious answer here, we could have gotten it from legislators. We could have had a carbon tax ages ago that confronted people with the real price of using these fuel cycles, but we don't have the guts to do it. So we rely on second best outcomes. How should competition law allow firms to respond to what could be called regulatory failures, where they're seeking collaboratively and privately to provide steps that governments are unwilling to mandate, which would provide complete protection? The antitrust laws at different times have taken different approaches on this. In the face of a dramatic economic crisis in the early 1930s, the Supreme Court famously allowed a group of coal producers to cooperate in effect, limiting their output of coal, principally for the purpose of raising price, but to improve distressing conditions associated with the reckless production of the resource. A different message comes through in the 1970s, where a group of professional engineers, a trade association, sign a protocol that says you cannot bid on price before the purchaser of the services selects the winning architect. Once the architect is selected, then you bid on price. But we agree that we will not bid on price And the rationale they gave was, if we bid on price, we're going to be in a death spiral to reduce costs, and that will provide inadequate quality, and people are going to die because physical structures are simply not going to be built appropriately. The Supreme Court there famously said, what you're telling us is that competition is a bad thing. And if it is a bad thing, go tell Congress. But until Congress decides it's not such a bad thing, you're going to compete on price in the bidding process. That could be seen as a very cautionary note to the accomplishment of what might be called good social purposes. I think Catherine put her finger, though, on the real question, which is what will be regarded as legitimate. And I could imagine a definition of antitrust law that defined the consumer interest more broadly to encompass exactly the kind of climate concerns that we've been discussing before. What are the antitrust agency nightmares? One is that these forms of collaboration are going to spill over into a host of other arrangements. Now, those could be contained with wise counseling, but does this become the vehicle for collaboration on all sorts of other things that don't deliver good results to American citizens, but deliver terrific results to the producers themselves? And is it opening the door? I'll just mention one other nightmare, to a variety of other arguments that will arise in the future about nutrition, about urban congestion, about environmental policy and the location of homes on the coastal areas. I mean, suppose that a group of banks got together and said, we will not lend you money to build within this area, this zone next to the coastline. We won't do that. What about a number of other social policy judgments that might be made, I would say, in the face of a regulatory failure? Part of what the agencies are worried about is that once the doors open, it opens to a large array of other considerations that ultimately will swallow the basic prohibition on agreements that restrict price. Now, I suspect one could design a system that's a lot more nuanced than that. You could define the consumer interest more broadly, but those are some of the anxieties that I think competition agencies bring to the process of evaluating efforts by firms to respond to what I'm going to call regulatory policy failure and inaction.
I think that's very helpful framing, Professor. Thank you so much. And Jeff, Professor Kovacic made the point that, competitor collaborations are not new. They have been around for many, many years. In fact, in the US, we have the FTC DOJ guidelines that were rewritten back in 2000, which, provide quite extensive guidance on the types of collaborations that firms can undertake. So I wonder if you could give us maybe a bit of a summary of what they cover. And again, I guess the question of what is fundamentally new about whether it's investor coalitions or firms wanting to collaborate on sustainability measures that are unrepresented in the existing guidelines.
Yeah, the guidelines aren't necessarily up to date, right? I mean, back in 2000, and they cover competitor collaborations in different contexts. And I think what they did at the time was provide some helpful scenarios that would try to give guidance to companies. But certainly in particular contexts, some of them include production collaborations where competitors come together and produce a particular product, buying collaboration where they're looking at how they can jointly purchase inputs. There's also R&D collaborations, and where you're looking at coming together and investing in research and development to push products forward to keep up with the technology. Even marketing collaborations, they take an analysis of that, as well as a more formal collaboration is a joint venture between competitors, where you're looking at them actually form a particular entity to then provide a service or product to the market. And the agencies provided the guidance in the context of how they're enforcing the antitrust laws, with the primary concerns, particularly of DOJ, is where you're talking about whether there's any output restrictions, effect on price, or allocating a customer, at least from the DOJ perspective. I think taking a look at what would be a hardcore cartel. in those contexts, as Professor Kovacic talked about, is what happens is competitors come together, but and certainly have these pro-competitive goals. But as they try and implement those pro-competitive goals, the conversations, agreements can then go into murky waters. And I think that's what DOJ and the FTC tried to, provide guidance on. But doesn't touch on sustainability. I think there's other resources that the agencies have put out there that give guidance, and probably more specific guidance in the context of sustainability. One is both the FTC and the DOJ allow for collaboration, competitors to come forward with their ideas and get an opinion letter, either through the business review process of DOJ or of the FTC procedures. And, the DOJ, I think there's a couple examples that do date back some time, a couple of decades ago, but post the guidance where DOJ considered proposals to create and adopt a workplace code of conduct. Back in 2000, they also issued a positive business review letter for the Akutan Catcher Vessel Association, which had proposed to suballocate a government set fishing quota to different processors, basically saying that they could each meet these certain quotas, potentially dividing up a market, but there are pro-competitive effects out of it. Then in 2006, the Fair Factories Clearinghouse, DOJ provided a response regarding their proposal to operate a database that member companies can use to collect and voluntarily share information about workplace conditions. I don't know if DOJ would have the same view of workplace conditions now if you're talking about wages and hours, given their guidance on labor markets back in 2016. But it certainly provides more on-point guidance for companies than do the 2000 guidelines. And I do want to raise one particular case that DOJ has brought, because I think it's instructive as to where this can go. And Catherine, we were talking before this started, is there real enforcement in this area? And what does that look like? In the case of US v. Leshevsky, where DOJ indicted the former CEO of Bumblebee in San Francisco back in 2018 for participating in fixing prices of canned tuna, DOJ actually had an interesting allegation in that. They asserted that the conspiracy included an agreement to limit and restrict competition between the conspirators as to certain types and categories of products, including but not limited to competition for products based on certain types of fishing methods. They tried to limit what products were available, as DOJ alleges, so that they could increase the price on the products that they were putting out in the market. And so that is where you're going to see, or you can see, enforcement. As far as in investor coalitions, I think, while the guidance back in 2000 doesn't directly deal with them, I think you can look at investor coalitions in the same type of framework. I think there's the same issues that arise. The concerns is whether, if there's going to be, if the standards aren't voluntary, if they're not loose targets but hard targets and have requirements on them, or people are supposed to take particular action. I think that where money talks, right? And so when you're making finance decisions on who can who is able to get financing, that is where I think antitrust law and some of the concerns of the agencies may come into place, because you're picking winners and losers.
Thank you so much, Jeff. I guess my reading in this might, set the stage, Maurice, for your comments in terms of how Europe and the UK are responding. But I guess my reading is that, the things that you described, Jeff, in the competitor collaborations, market allocation, price fixing, and so forth, traditionally have been per se illegal, right? They've in antitrust law, that they are that they don't need an additional analysis, that those are considered, outright illegal. what I've heard, at least
And
some,
I just add, Denise, you go to jail too, routinely.
right.
That's all grand jury stuff. Yeah.
Absolutely. No, thank you. So it's a criminal provision in the Sherman Act, Section 1. But what I've heard companies saying is that what's different this time with sustainability is that they would like the agencies to revisit these per se legislative texts, and in some cases they are desiring, exemptions for coordinated price rises for different types of what traditionally would be considered cartel behavior in order to gain a sustainability benefit. In some ways, it feels maybe that's not so unique. I mean, as Catherine mentioned, we have efficiencies defenses, which do similar things. And so, Maurice, I'm wondering if you can sort of speak to, there have been some quite bold movements in Europe, particularly around, this area. And I wonder if you could speak to what's been happening in Europe and also in the UK, and give us an overview there. And then we'll also talk about why the US is a little bit more complicated in terms of, providing clarity on some of this.
Thank you. It's a pleasure to be back at the alma mater, so to say. I was at Columbia a long time ago. Now, before talking about what different countries are doing, we have to look at what countries have in common, and that's the economics and the policy. Competition law is supposed to safeguard effective competition to ensure an effective allocation of resources to preserve consumer welfare. Now, market failures get in the way of that. And the reason is externalities. There is no price for emissions. And that means that producers normally have no incentive to cut them. And it's worse, unmitigated market forces can actually drive companies to exploit nature and the climate as much as they can. So consumers do not get the best deal. There are hidden costs to their production and consumption in the form of climate change. And in fact, Stern and Stiglitz say that climate change is the greatest market failure the world has ever seen. Now, collective action problems block correction of these market failures. We need cooperation to deal with these collective action problems. And it should be allowed, if you think about it, when public and private goals coincide, when companies seek long-term benefits and positive externalities to overcome market failures, collective action problem, and the kind of regulatory deficiency that Bill Kovacic was talking about. Also, those agreements should be public, not secret. There should be stakeholder involvement. The internal evidence should be consistent with the public statements, and they should be open and not exclusionary. Now, let's have a look how various jurisdictions are dealing with that. First, you have the UK. The UK has recently consulted on environmental sustainability agreements. These, by the way, are limited to environmental and climate agreements, not the other 17 social development goals that Bill was worried about. That consultation provided thoughtful guidance on various types of agreements. They set out, on the one hand, agreements that are unlikely to restrict competition, like standard setting, phase-out agreements for non-sustainable products, industry-wide targets, information sharing, situations where the parties cannot act alone to create a new product, and so forth. Then they look at ancillary restraints. These are agreements which are reasonably necessary and proportionate to an otherwise pro-competitive objective. Now, that's quite novel to apply that in the climate sector. The EU Court of Justice has already applied that in certain other sectors like sports regulation, but not yet in the climate. So that's quite novel what the CMA is doing. Third, they have a more permissive availability of exemptions. Those are the 4 points that Catherine McKenna was talking about. Most important is that an agreement must be reasonably necessary to achieve a climate goal, like a reduction of emissions, and a fair share must benefit consumers. Now, the CMA says we count all consumers in the UK. We don't just look at the consumers who are in the market in question that is affected by the agreement. We look at all consumers. That's novel. They also have an open door policy. So as a result, the CMA is now firmly at the forefront of the debate. There's a little bit of criticism. Why only look at UK consumers? This is a worldwide problem. And why not include, for instance, biodiversity? That could also. Now, the EU is quite consistent, but not as permissive as the UK. The EU has consulted on horizontal agreements as well. They are also expected to issue final guidelines. And it has done two things, broadly speaking. It's defined a broad, what they call soft safe harbor for sustainability standards, subject to a number of criteria. And this is wider than the UK, since it's not just limited to environmental and climate agreements, and what is defined as a standard setting is quite broad. The EC has also expanded the scope for exemption, but not as far as the UK. They say, for instance, that collective benefit, like climate change risk reduction, can justify restrictions only where, and I quote, consumers in the relevant market substantially overlap with or are part of the beneficiaries. So they limit the number of consumers, they limit what benefits they count. And I think that that's a potential criticism there, because they might then prohibit agreements which from a worldwide perspective are really necessary and good for climate change reduction. So that's one concern. There are also, and broadly speaking, I've heard a chief economist in the EU say, why should we tax consumers in order to create, in the EU, to create benefits for the rest of the world? And to me, it's exactly the wrong way around that question, because consumers and producers in the EU impose social costs on the rest of the world, and it should be permissible for them to agree to eliminate those social costs. And eliminating those social costs is pro-competitive, in my view. So the debate in the US is much far less advanced. We've had John Newman, who wrote a fascinating article about the output welfare fallacy, really worthwhile reading. And Emilia Miazad wrote an article on pro-social antitrust, also very much very readable and very necessary to understand. Now, why is that? Why is the US less far advanced? That's probably not just because of the way that US antitrust enforcement is organized. It's a remnant of Chicago school thinking, which focuses completely on short-term price effect, ignoring externalities. And the new Brandeis movement is completely blinkered focused on digital markets. They seem to ignore the climate and the environment. And then you have political polarization and the weaponization of antitrust, which I find very difficult to understand as a European, because even conservatives should care about the climate and about clean air and clean water and a stable environment. And so after all, it's the conservatives who started with the protection of national parks and so forth. So they should do that here as well. But that said, the fragmentation of US antitrust makes coordination difficult. You have the DOJ, the FTC, the state attorneys general, the federal courts, the state courts, for private actions and so forth. Now, and then I'll shut up, but I will make one more point. Coordination is possible. And they look at President Biden's executive order of January 27, 2021. Section 201 says the federal government must drive assessment, disclosure, and mitigation of climate pollution and climate relation risk in every sector of the economy. He demands action that combines the full capacity of the federal government. He says it's the policy of this administration to organize and deploy the full capacity of its agencies. Section 219, agencies shall make achieving environmental justice part of their mission. Section 222, he wants to ensure the comprehensive attention to environmental justice throughout the Department of Justice, and that includes the antitrust division. Now, I could go on. There are other presidential executive orders, but so there is scope for that kind of coordination in the US as well. Thank you.
Thank you, Maurice. That's really very helpful. And I'm going to switch up our order because I think one of the things that you alluded to here with the neo-Brandeis movement and so forth is that, Bill, I wonder if you would agree with this, that in Europe, the most of the focus has been on expanding definitions of the consumer welfare standard to include sustainability considerations. Whereas in the US, there's sort of a larger active debate among practitioners and academics about how to reconstitute antitrust law to meet a number of different market realities, including digital markets. And to Maritz's point, sustainability sort of doesn't really factor in. But I wonder if you could talk about perhaps some of those debates and about moving beyond the consumer welfare standard and unpack perhaps the differences between the US and Europe in that regard.
Yeah, we need an entirely different vocabulary in the US. When you go to a program, you say consumer welfare, people drop the gloves right away and start fighting without defining terms. Maritz just gave one, but for a long time, competition law throughout administrations has been concerned with a lot more than just price effects. Quality, innovation show up in lots of cases. So I think we need a new way to define what we mean by the consumer interest, and perhaps going back to the question of what do consumers regard as being a suitable manner of organizing the economy? What kinds of effects do they look for? That's inherently very elastic. That looks at, if you just look at the traditional concern about quality, one dimension of quality in the production of goods and services might be accounting for these externalities. So that I suspect what we're going to see over time is a development of a new way of speaking about this that is perhaps more broadly encompassing. As Maritz said, the current administration and its leadership has not been receptive to the idea in the antitrust departments of taking this step. And I see in their pronouncements a real anxiety about where this goes. Maritz mentions that the US system is highly fragmented. Lots of commentators point to that as an enormous strength. That is, if public authorities at the federal level default, then you've got all the states working on this. Private actions, there's a massive volume of commentary that points to that decentralization as being a tremendous strength, even though it's very messy. In addition, you look at the Biden executive order, how fascinating it is. There's not a lot of guidance there about how to reconcile these concerns. That document has arguably some contradictory messages. It says, antitrust agencies, I want you to abandon what he refers to as 40 years of failure. That's a message to go to the barricades and start applying the law vigorously and in an extremely tough-minded way. There's not a lot of nuance there about how to account for these other factors. So we're far away from having the mechanism that coordinates the behavior of all of these public institutions. And I think a difficulty for the new leadership is you ascend to power by saying the weakness in the system has been inadequately robust enforcement. That pushes you in the direction of doing more across all fronts. It doesn't give you a great deal of flexibility for the more nuanced accounting for what represents the larger consumer interest. And again, I suspect a concern in the enforcement community, perhaps even in the CMA, in the European Union, is what amount of reduction in output of harmful effluents justifies a given increase in price? That is, by what calculus do I trade off price increases against the abatement of pollution? That's a really tricky analytical issue for an agency that's deciding whether to approve a proposal or not. So I guess in short, we need a new vocabulary, one that more accurately reflects what agencies have actually done. And on its own terms, that vocabulary could embrace a broad notion of what consumers regard to be important in individual transactions. But yes, there are a lot of features in the US system that make it hard to reconcile the tensions that Maurice mentioned, especially because so much of the modern commentary about competition policy said that fragmentation is terrific, and what we need is more powerful, potent, aggressive enforcement, not less.
Well, and I think that raises where I want to sort of get out of the competitor collaborations frame for a second and move to other areas of agency enforcement authority in terms of merger review and greenwashing, because I know, in the U.S., one of the sort of animating forces of the new movement is a concern on market power and the merger policy and how that's been adjudicated over the last number of years. And Jeff, I'm wondering if you can speak to how areas like merger review or consumer protection could potentially be a boon to sustainability efforts going forward.
Yeah, certainly. I would like to come back to President Biden's executive orders, just maybe at the end if we've got time, because I think I agree with Professor Kowicich that there's somewhat of a inconsistency there, and certainly left the agencies on the side of we're going to look at this in the lens of enforcing. And that's where, especially at DOJ, from my perspective, I've seen they're looking at these collaborations with an eye towards, what restrictions there are anti-competitive. That's their first question, and that's where they're trying to piece the facts to fit that narrative. As far as, but yes, merger review, companies, if they consider developing and meeting their own standards, if they themselves can't meet those standards, they may go out and look for companies that can help them obtain their goals, and that is obviously very pro-competitive, and the agency should consider that as companies trying to make that effort and meeting those goals, and shouldn't take the view that they're trying to eliminate or kill a potential competitor in the ESG space or sustainability space. I think it's just how they approach enforcement is going to be really important. Absolutely, as far as consumer protection, I think that's an easy one. Greenwashing, false claims of what products may do for the environment or how be helpful to the environment, if those are wrong. The FTC has put guidance out there, and it is very, it's got a long history in the space of, ensuring that markets and consumers are having trust in those markets. So I think that can absolutely be a boon for sustainability efforts.
Great. And Catherine, I'd love for you to comment on that as well, given this has been a core part of your work. How should competition and consumer protection agencies think about greenwashing, especially at various levels, product level claims, firm level claims about net zero goals? How should they think about that?
Well, I guess they just have to tackle it. We've seen in Canada, look, this report, I don't want to hang everything on this report, but short of regulation, we need to have some clarity. And certainly in the Canadian context, I was heartened to see that action was that the Bureau took a complaint seriously, looking at the net zero report and just saying that actually the claims were not consistent with what is required to be aligned with net zero. Because I think it's very easy for folks to say we're net zero. Everyone's net zero now. So, in a good way, that's great. Everyone wants to be net zero, and especially publicly traded companies, because they feel that that's important for consumers. The reality is, though, some either don't understand what is required to be net zero or want to engage in greenwashing. They think it's good for business and they can get away with it. And so we've seen in Canada, so once again, I can't speak in other contexts, but in Canada, the Bureau at least is conducting investigations and looking at the standards that are the criteria that are set out in the report. Look, this is important. Why is it important? Because the market, we've talked about market failure. There's huge market failure, and we rely on good information. So consumers or shareholders or investors rely on information. And so if you're actually saying you're clean or green or you're net zero, whatever, you're not, then that is a real problem. And I'm all for consumers being able to vote with their dollars. So that if a company, you want a product to be net zero, you want it to be net zero. And the way you can do that is by holding folks to account. And actually there's been movements, for disclosure, and Macron is a little bit off topic, but I think it's still important because I think disclosure and having good information is so key. President Macron and Michael Bloomberg have created a net zero data utility where they're going to be posting this information in a comprehensive, comparable, and public way. Because right now it's extremely hard to get this information, and then you have to rely on competition bureaus. And in the Canadian context, they don't really have a lot of teeth when it comes to misleading advertising, but doing massive investigations. We actually just need the information there. So if you're a young person or anyone, an employee looking for a job, you have the information about whether company's net zero. I'm quite focused on net zero. That's my thing. Obviously, there are other measures, ESG and I guess green, although that doesn't always mean much. But, there is a price of admission, and the more that we can make it clear on what is required and what is not allowed, so that we can hold, folks accountable for the claims that they're making, I think the better it is. Now, devil is in the detail. It is not actually all that easy. And I think we're going to need to see more clarity. I know in Canada, they're looking at how to reform the Competition Act and the misleading advertising provisions. I'm not always sure whether you need to be tailored to specific issues like greenwashing. Sometimes it's supposed to be an act of general application, but in this context, you may need to. And we've already had a massive discussion about market failure. I mean, to get back, because just to get a little spicy again, I think that, what I'm quite interested in is, okay, we all sort of see there's a problem here. So how do we, is there going to be a solution? Because we don't have time, because I'm just worried. We can all talk this is all really an interesting academic discussion, and where is this in? And is there areas of room? I don't know. The planet is heating up at a rate that, we're threatening our very own existence. And we're talking like lawyers, which is fine because we are lawyers. Or I guess we're all lawyers, I don't know, or academics. But the reality is, I don't know, I'm just a practical person. That's why I got into politics. That's why I do what I'm doing now on climate. And so I think it's incumbent on all of us to really push the envelope on this. It's a bit disheartening from my perspective to hear the Biden administration, who's so committed to climate action, is kind of leaving this open. I get there are always problems, but I think even the cases I've heard, I think they're distinguishable. I don't want to go down that road, but I think that we're talking about the difference between price fixing and saying, actually, the science says you got to get out of coal. I think they're probably a bit of distance. Having said that, yes, if there are real risks, we need to address it. So I'm just hoping that that's possible. I worry in the US context. I'm not American. I spent a lot of time in Colombia. I love Colombia. I love the US. That the politicization of almost everything becomes a problem, including in areas where you would hope it wouldn't be politicized. It would be about the market. It would be about proper functioning of markets. But I'm not sure, and we haven't talked about this, so I don't know. When I look at this and I think about why folks wouldn't want to take things on, I was a politician. Don't take things on, are going to kill you. Is this an issue? Is the politicization and the discussion around ESE, attorney generals taking cases and doing these things, does that make it even harder to do something around, a topic that is politically divisive, although I wish it wasn't, because it's just science and physics. But I don't know. I don't want to go down these roads because we can keep it at a more academic level. I just am how do we do things that are good now?
I have a response to that, but I don't know, Bill, if you do, I'd like to also leave some time for audience questions here. But I do think that the agencies feel very politically constrained. The FTC is facing a barrage of attacks, questioning its statutory authority to even exist. And so I think there's a real reticence to sort of engage in debates that would put them even further in the crosshairs without being able to execute their existing mandate, let alone an expanded mandate.
I don't want to offer this as a rationale for inaction, but just to identify the state of mind, perhaps. What we're talking about in some ways in making these judgments is making judgments about what kinds of measures, even though perhaps they do restrict output in some ways, restrict them in ways that will ultimately be good for the society, but also have shorter-term price effects so that people are going to pay more? What is the methodology that a competition agency would use to make that kind of judgment? These are the judgments that we usually expect legislators to make. So let's assume that our legislators won't do it. They've defaulted. Should the competition agencies basically stand back, seeing the house burn down and say, I'm going to wait till the correct fire department shows up with the right hose to put it out. Otherwise, I'm going to watch the conflagration. Should they step in? And there are lots of ways in the past where agencies, in a sense, have stretched to deal with exigent circumstances. I'll just mention there will be a political feedback loop. So Congress won't act. They won't make the trade-offs. The agencies say, damn it, I'll do it. They do it. Now comes the Congress saying, who told you to do that? Who gave you the mandate to make those kinds of value judgments? That's our job. And in the past, they've often responded in a vindictive way. And if I am the FTC today, and I'm trying to go after non-compete agreements nationally, I'm trying to change the basic guidelines for merger enforcement in a fundamental way. I'm seeking the divestiture of some of the largest, most heavily capitalized companies on the planet, along with the Department of Justice. I look at what I'm doing and I say, there's a lot of risk in that portfolio that I've invested. How much more do I want to put in the portfolio? And I don't suggest for a second that the issues we're talking about now are unimportant or should be treated as secondary. But if I am at the FTC now, or if I'm at the Department of Justice, I'm wary about how much risk I put in the portfolio, and I'm very concerned that this legislature, that for a variety of reasons won't act, won't make the choices that need to be made, allow by default me to make those choices. Then there's going to be retribution when I don't make them in quite the way they want. Do I have a solution for the political economy problem in the United States? I don't, but I'm simply describing the state of mind that I think makes public enforcement officials in the US anxious about how readily they dive in to try to take this on and to march into the building and to try to put out the fire.
Okay, we've got a number of questions here about investor coalitions in particular, so I'd like to perhaps combine them here. So a question from Beth Young, who has done some fantastic scholarship on First Amendment. Many investor collaborations do not involve communication among companies, but instead engagement between one or more investors and individual companies with the goal of convincing the companies to adopt some best practices. Some actors on the right are painting a picture of these collaborations as hub and spoke conspiracies, enabling the engaged companies to engage in conduct in violation of antitrust law. This has already had a chilling effect on investors. What's your view on the strength of this theory? There was a sort of corollary from Frederick Alexander. Is that a possible argument that supports investor collaboration without having to redefine or clarify consumer welfare standards, the sort of investor diversification and their internalization of costs that individual companies are now externalizing? So the sort of universal shareholder theory, if folks are familiar with that. I don't know who would like to tackle that, but
I'm happy to start.
Go for it. Thank you.
Doesn't look like hub and spoke to me. Hub and spoke is a situation where you have one competitor and another competitor cooperating and communicating indirectly through somebody else, knowing that what they tell them is going to influence what the hub tells the other part of the party at the other end of the other spoke, and vice versa. You don't have this here. What you have here are investors concerned about long-term risks of their investments, because they may end up with stranded investments, and it is part of their fiduciary duty to their shareholders to ensure that they are not ending up with stranded investments, and that they do not invest in products or companies which will have negative externalities for their other investments and their own activities in the long run. So to me, this does not look like an antitrust issue. It seems to be kind of a straitjacket to put that into hub and spoke, to say that this is hub and spoke cooperation. To me, this sounds like a manageable and reasonable cooperation between investors to meet their fiduciary duties and their long-term interests. I could go on, but
I think Moritz gets it just right here. I think there's advice you can give to the intermediaries to assist them in being sure that they don't engage in the kind of interaction that Moritz correctly describes as being a hazard. I mean, their intermediaries can get in trouble, but there are things they can do to avoid that. And I think Moritz has described what those are very well.
Oops, there's a follow-on question here about, it's a bit technical, but if higher price, lower output results from a decision to reduce greenhouse gas emissions, is it a defense that there is no wealth transfer to the corporate side because they moved the supply curve up so that equilibrium is in a different spot rather than price fixing where you actually price above equilibrium in order to recapture a consumer surplus? So curious if someone wants to take that one on.
I definitely don't.
I'm happy to, but
Go for it.
well, to me, this is crucial, right? Because that, for instance, the net zero alliances are a perfect example. These are alliances that are not trying to cooperate in order to get higher premiums for themselves or higher profit for their businesses. They are cooperating in order, well, at least they might be cooperating in order to reduce risk and negative externalities of their own activities in their industry to the benefit of society and everybody else. So when you look at the assessment under antitrust law of an agreement, the first thing you look at is the nature of the agreement. Is it as a cartel intended to raise your profits? That smells. That's definitely not what these agreements are here. Now, there could be situations, there's been some discussion about the fashion industry where they were trying to do the right thing in order to reduce fast fashion and throw away clothes and so forth. And then unfortunately also straight into talking about discounts. You know, these are the kind of questions where there might be a little bit too much spillover, but the bottom line is it is very relevant that if there's no wealth transfer to the company in question, that's an indication it's not a cartel.
I think there's a way to address this, and Moritz anticipated this earlier, which is you can have safeguards in place. If you're going to have an agreement, understanding, and collaboration, that's publicly filed with the relevant agency. You're not formulating the deal in a covert manner. You register. You can have a mechanism where you register the agreement. If the agencies wanted to engage in a further exploration of this in the U.S., they could have the kinds of workshops and public consultations that have taken place in other countries, where people bring forward the concrete scenarios they're concerned with. And you have a discussion where agencies and affected enterprises go about thinking about where the real harm would be or would be absent, what benefits might be generated. That is, you have procedural mechanisms that point you into the direction of making a better judgment about just what the effects are likely to be, and you have good process of the kind that Moritz described before.
Yeah, I mean, from my experience in counseling companies on this issue, there's usually always a path forward that they can achieve their true goals, and it's just putting those guardrails up, as you say, so that conversations don't go into anti-competitive areas where they were not intended to go in the first place. So we've always seen ways to get coalitions into the right spot and avoid the antitrust issues that are out there, the perceptions that there's a problem.
Denise, could I ask a question? Once again, I'm in problem solving mode here. Okay, so we have agencies that are worried about doing things. We have politicians who don't want to do things for potentially political blowback or for other reasons. In Canada, the competition bar is quite active slightly nerdy, but it actually does, I guess, collaborate amongst themselves to come out with positions. I mean, it would be helpful because one thing I did note, so when this all came up, when people are like, you know, GFANS problems, what people are doing, I was like, okay, great. So who's doing some research on this? Good news, I found Columbia was, but there really wasn't a ton of work on this. But I was like, this is bonkers. This is obviously an issue. And, you know, and it's normal, I guess, because these are voluntary initiatives that are for good purposes. And people aren't flipping competition antitrust lawyers. They're just people who are trying to work on climate. And just think it's obvious because like kind of many people would, if they heard us discussion, they might say this is kind of weird, a little bit, okay, just a step back, because the reality is they would say we've got a massive problem called climate change. We actually have to do what the science tells us. This is what this is doing. They're doing it in a public way. It's not like secret. No one's talking about like we're gonna, you know, actually can make loads of money if you don't actually participate in this. It's way better right now. So I'm just wondering, is there any movement for competition or antitrust lawyers in the US to stand up and put their neck out and kind of say, all right. And I know we've heard 2 articles, so that's great. I'm going to go like, please source those articles. But could there be a movement of folks who actually care? Because what my concern was, it seemed like there was a lot of conflicts because I was like, okay, could someone just like out of my own, like I'm not engaged in that, but I just wanted to understand this. So I was like, okay, who's working on this in a pro bono way? Couldn't really, okay, we got Moritz. So I should have called some of you guys, I guess, but I couldn't actually track it down, which slightly worries me because we are lawyers. We actually try to do good things. I think we believe in things that are important. And I just would hope, because I mean, there are some folks, and I'm just going to say this, so people might not like me saying it, but there's some folks who don't actually want to do some of these things that are required to do on climate because they can make money. Now, they may say there's a fiduciary obligation, and I'm not going down that rabbit hole because I think there are arguments against that. But I do think it is important for folks that have the knowledge, us here, others, to stand up and say things. Because it also helps, and I'm thinking about this in Canada, we do have carbon pricing, by the way, we landed it. It was not very fun, I had to do it, but, and I needed the support, not of environmentalists, to be honest, I needed support of business. So we created a Carbon Pricing Leadership Coalition, they stood up. I'm not talking about this at antitrust issues, I just am talking about like folks put their neck out. And so I'm just pleading, if anyone's on this, you folks here, but others, that it would be really helpful for people who are super smart and are leaders in this field, including who work with business, to actually not talk about the risks as much as the solutions and how you can design, looking at the US context, but also what is happening globally, to like how you could design it, because that may actually stiffen the spine of agencies and support businesses so they stand up and put up their hand and say, we need to do this.
I see folks are cheering you on in the comments here. So thank you for that call to action, Catherine. And I think it's a great way to finish this webinar. And I'm so sorry we didn't get to all of the brilliant questions here. There was a desire to see some of the reports that were referenced. We'll definitely send out Catherine's report that she's been referencing and some of the others that came up on the call. If folks on the call are interested in working on this, one of the things that we're trying to do with this sustainability and antitrust landscape analysis and mapping is to actually put together a contact list of people who are working on this actively so that we have visibility with that. And so if you're on the call, please feel free to get in touch with me, Denise at denisehearn.com, and I can follow up with you from there. But I do want to thank all of you so much, all of our panelists, for joining. I think this is a fantastic kickoff to this conversation. There's a lot more that we could say and do. So maybe we'll have to reconvene at some point in the future, but I appreciate, Catherine, you focusing us on the ultimate goal here, of course, which is creating a thriving planet and figuring out the mechanisms to do that in ways that don't undermine our objectives ultimately. So thank you so much.
May I put in a plug for the ICC Competition Law Network, the Net Zero Lawyers Alliance, and a variety of others. So there are those, and I'll send them to you, Catherine.
Amazing. Well, I guess you've all signed up now. And everyone who's following this. No, anyway, thanks to everyone. It's been great. And thanks, Denise.
All right.
Yeah.
Thank you so much, everyone. Take care. Have a great rest of the day.
Bye-bye.
Thank you. Bye-bye.